I'm from Reignmont Estate. I would like to buy your land located in Blaw. So basically, what's the price of the land?
The price of the land is 12.6 million.
To show our absolute commitment, we are paying 10% of the deposit for the land, which is amounted to 1,260,000. Alright, thank you.
Okay, we acknowledge the receipt of the 10%. However, let us be perfectly clear. This deposit does not bypass the law.
Exactly. This 10% is held, but the transfer remains frozen until the ELB issue a formal approval.
We have done our part. Now we wait for the approval of ELB.
The defendant agreed to sell the 116.95 hectare of oil palm estate to the plaintiff for 12.6 million ringgit. Because the land was classified as estate land, the sale was conditional upon approval from the Estate Land Board, known as ELB approval.
This extension is our final approach. This deal must go through.
Okay. However, if ELB approval does not arrive within these 3 months, the contracts will be ends. There will be no more further extensions. Okay?
I know.
I will be signed.
Yes, I know.
Assalamualaikum, Mr. Zul.
Salam.
Actually, I want to inform you the 3 months have expired today. We have no confirmation of approval from the land office.
Then, the contract is void.
Exactly. Under Section 36, Clause 1 of the Contracts Act, because the condition failed within the fixed time, we are legally entitled to terminate this contract.
Meanwhile,
Assalamualaikum. Waalaikumsalam.
I just received the revoke letter from the Jaya Ikatan.
The revoke letter from Jaya Ikatan.
Yes.
They are backing out because the land prices are skyrocketed. They never intended to finish this.
We will sue for the specific performance.
Yeah,
We will
sue them,
prove
sue, yeah.
that they are hiding the truth.
Yeah, okay.
When ELB approval was not confirmed within the 3-month period, the defendant invoked Section 36 (1) of the Contract Act 1950, declaring the contract void. The plaintiff sued for specific performance, arguing that the approval had actually been granted earlier and that the defendant had breached the contract.
All rise. The High Court of Malaysia is now proceeding. Reignmont Estate Sdn versus Jaya Ikatan Plantations Sdn. Parties are present and ready.
My lord, the defendant acted dishonestly. The land office actually approved the transfer back in 2008, yet the defendant suppressed the fact to escape the deal when the price roses.
This is serious allegation. I would like to call the witness from the land office to give the evidence in order to clarify the issue.
Approval was granted on 28 September 2008. We have sent the letters to the defendant's solicitors.
So the ELB approval existed all along?
Yes, but we have no proof about the letters were ever received.
My lord, our firm relocated officers during that period. We never received those letters. More importantly, the plaintiffs were never truly ready to complete this purchase.
Specific performance is an equitable remedy. Was your client continuously ready, willing and able to pay 12.6 million?
We paid the deposit, my lord. We also discussed financing with its various banks.
Discussed but never approved. The plaintiff is a company with a paid-up capital of only 2 ringgit. They have no loan letters and no proof of funds. The deposit is not the purchase price.
After hearing both from the plaintiff and also the defendant side, all please stand to hear the final ruling.
First, the defendant was entitled to terminate under Section 36, (1) because the condition of ELB approval failed within the agreed time. Second, the plaintiff failed the ready, willing and able test. A company with 2 million capital and no financing cannot compare a 12.6 million sales.
The High Court dismissed the claim. The court held that ELB approval was a contingent condition, not a promise by the defendant. Since the condition was not fulfilled within the agreed time, the contract became void under Section 36 (1). The plaintiff also failed to prove that it was ready, willing, and financially able to complete the purchase, a key requirement for specific performance. Additionally, the court found that damages were an adequate remedy, rebutting the presumption under the Specific Relief Act 1950. In conclusion, this case shows that specific performance is discretionary and contracts dependent on uncertain events will fail if conditions are not met on time. The law protects certainty in contracts, not delay or indecision.